Hello everyone, I'm Holden, this is Nick. The case we're going to be presenting to you today is Perka v.The. Queen.
Alright, so quick outline. We have the case overview, then the trial, the majority decision, necessity, and the conclusion. So the accused, William Francis Perka, Paul Oscar Nelson, William Terry Hines, and Stephen Earl Johnson were all accused of smuggling 33.49 tons of marijuana from Colombia to Alaska. During their voyage, the ship encountered rough waters and had multiple problems. This included engine breakdowns, overheating generators, and malfunctioning navigation equipment. So with the worsening weather, it was decided to seek refuge on Vancouver Island in No Name Bay. This is where the ship ran aground. The captain ordered his crew to unload the cargo. This was due to fear of capsizing. And on May 22nd, 1979, Canadian authorities entered the bay in police boats. The vessels and cargo were seized and the appellants were arrested. They were all charged with importing cannabis into Canada and with possession for the purpose of trafficking. So at the initial trial, the accused brought into question the defense of necessity and the botanical defense. The Crown failed to prove the accused were not in necessity, and the trial judge accepted the defense of necessity but withdrew the botanical defense from the jury. The Crown applied to rebuttal the evidence about the vessel, but it was refused. The Crown then appealed to the Ontario Court of Appeal, and the acquittals were reversed. The Court of Appeal held that the trial judge was correct in withdrawing the botanical defense, but erred in not allowing the Crown to rebuttal.
So I'm just going to go over the Supreme Court of Canada's majority decision in relation to this case. So the Supreme Court of Canada ruled with the initial trial judge that the defense of necessity was successfully applied and the acquittals were reinstated. Once the defense of necessity is raised, the burden lies on the Crown to disprove it. The Supreme Court Judge Dixon then set out how the defense works. Dixon goes on to say that it does not matter if you were engaged in illegal or negligent activity when the necessity arose. All that matters is that you were in a state of emergency. So the definition, just for some background, of necessity is emergency situations where normal human instincts, whether self-preservation or of altruism, overwhelmingly prompts disobedience. Necessity is not a justification for the action, but rather a legal excuse. For the defense of necessity to apply, the following criteria must be met. 1. There must be an emergency involving clear and imminent peril to be determined using a modified objective test based on what a reasonable person would do. So 2. There must be no reasonable legal alternative to what is performed, also determined using a modified objective test. And thirdly, one must look at the proportionality of the legal act compared to the harm avoided using a standard objective test, as falling for subjective input would make the criminal law inconsistent. So just a conclusion of our presentation here. The Supreme Court of Canada agreed with the trial judge and acquitted the accused on the charges of importing cannabis into Canada and with the possession for the purpose of trafficking. The defense relied heavily on their necessity defense, which got them acquitted. The defense of necessity is not a justification, but rather a legal excuse. And Perka v.The Queen is an important case in Canadian law because it is set out what criteria needs to be met for necessity to be successful. Thank you.